Hi, I'm Lee Fisher. I'm the Dean of Cleveland State University College of Law, and it's my honor today to interview for my BarStory Steve Kaufman, the former president of the Greater Cleveland Bar Association. I've known Steve for decades, and when Steve asked me to do this, I jumped at the chance because I don't think there is a better trial lawyer in Ohio, maybe the country, and I don't think there's a better trial lawyer with more stories than Steve Kaufman. So let me tell you a little bit about Steve. You're going to hear mostly from Steve today and not me. Steve grew up in Merrick, New York, the South Shore of Long Island. He graduated high school in 1968. He went to Colgate, graduated there in 72, and graduated from Case Western Reserve Law School in 1975, 1 year before I graduated from the same school. He married his late wife, Loretta Quaid, who I had the great privilege of knowing for many, many years. Loretta was a classmate in law school with Steve. They have two daughters, Sarah and Leah. They became a doctor and a lawyer, married, and Steve now has 4 grandchildren. In terms of Steve's professional career, he was a law clerk for the late Judge Jack Day, Ohio Court of Appeals. And if you know anything about Jack Day, he was a legend in his time, and even more so now. A phenomenal person, a phenomenal lawyer, and a phenomenal judge. Steve early on practiced solo, but eventually, he wanted to be his own employer. And so Steve started his own firm in 1982. I can tell you it was a highly successful firm, but a lot of other firms wanted him as their partner too. So it's no surprise that he actually, after doing that, went to 2 national firms. And he's practiced now for 42 years. He's been named as a great lawyer by Best Lawyers in America, by Benchmark Litigation Ohio Star, Ohio Super Lawyer, Best Lawyers in Real Estate, Lawyer of the Year in 2019. The Weatherhead School of Business named his law firm not once, not twice, but 3 times as one of the top 100 businesses in Ohio. Pretty impressive. So, Steve, do you think you can live up to all this hype?
No, but thank you very much. Are we done? Oh, thank you.
Steve, I'm going to begin by asking a general question, and that is, let's work backwards. Tell us what you're doing right now in your life, professionally and personally.
Thank you. And thank you very much for a very kind introduction. And Lee has been a great friend for so many years, and there was nobody else that could do this conversation with me other than Lee, so I appreciate it. Really, I retired at the end of 2021, largely a full stop. I'm still handling a few matters for a few clients that needed me to continue to help them with the case. But apart from that, I've done a full retirement. We bought a place on Sanibel Island, Florida, where we're going to plan to live about half the year. But I'm not sitting idle. I'm writing a book. I have plans for a couple of others after the one I'm writing. Fishing, visiting kids and grandkids around the country, and starting to do some travel. I was remarried at the 3 days before I retired, and so Reza and I live here in Cleveland and in Florida. But I'm loving the decision I made, and frankly, everything was telling me to retire at the end of 21. My head, my heart, my body in particular, and it was just the right time for me.
I have to admit, Steve, it's hard for me to picture you as retired because I don't think I know anybody, including myself, and I have a strong work ethic, who works harder and longer hours than you. You are, if somebody said to me, what's the word you associate with Steve Kaufman, I'd say prepared. He's always prepared, and you can't be prepared without working your tail off all the time. And that's why you've been such a great trial lawyer. Do you agree?
Well, thank you. Yeah, it's, when all else fails, if you're ready, you're exceedingly well prepared, you're generally going to be the most prepared person in the room. And that was always what I try to do. So 2 things about that. One, my wife knows how much energy I've got. And I said, hey, now that I'm retired, I could devote 100% of my energy to you. And she laughed, and that scared her a little bit. And but our place was destroyed in Sanibel by Hurricane Ian, so now I'm sort of channeling my energy to rebuild. But it was really something that having energy is what kept me going that long.
I want to focus primarily today on stories. So let's talk about the story that led you to want to be a lawyer to begin with.
Yeah, thank you. Yeah, and for me, it was a moment when I knew what my mission would be. I was 17 years old, senior in high school. My dad, who was pretty active in the community, was asked to get a speaker for the graduating class, which I was a member of. And so he picked Harris Wofford, who had been the Peace Corps director under Kennedy. Since then, he has been the president of a couple of colleges and universities and was a U.S. senator. But at the time, Harris Wofford came in, and we went to New York that night before the speech and had dinner with my folks. And then my folks gave us 2 tickets for me and Harris Wofford to go see The Man of La Mancha, original Broadway show. And I had read Don Quixote but didn't appreciate it. And saw that show, and it grabbed me. It grabbed me, particularly the song, "To Dream the Impossible Dream," "To Fight the Unbeatable Foe," "To Bear Unbearable Sorrow," "To Go Where the Brave Do Not Go." This is my quest to fight for the right, no matter how hard, and to be willing to march into hell for a heavenly cause.
Would you sing that now, please?
I will off stage here, but
Okay.
But that song and that show grabbed me, and I said, you know what? I'm going to spend my life trying to help people that need a voice, trying to help people who are the underdog, who have a great cause and a great principle, but look like they're going to be sort of overwhelmed by the forces of the world. And that I knew would be my mission. What I would specifically do, I didn't know until a few years later. But that's always motivated me ever since that moment in 1967.
Well, knowing your trial career, I think you debunked the notion that there's something called an unbeatable foe, because you actually had many beatable foes who started off unbeatable, but you won. So let's talk about why you chose trial law.
A great question. All throughout junior high and high school, I'd been on the debate team. And debating in traditional debate was about a proposition that you would debate for the whole year. And it was all about ideas, public policy, and reasoning. But you had to be able to debate on either side of the topic. So you had to be able to switch from one to the other, and you go from round to round. And I was successful all throughout junior high and high school in these interscholastic competitions. And it taught me how to organize an argument, make it short, make it simple, make it convincing, and try to convince your audience, the judge. As a senior in high school, I entered not a debate skill, but it's called extemporaneous speech, where you would go in and they would give you a topic, you pull it out of a hat, and you would have 30 minutes to prepare on that topic to give a 10-minute presentation to a panel of judges. So the first time
And that was before Google.
That was before Google, exactly. I had to
So
bring
that 30-minute preparation is pretty hard.
I brought in a thesaurus, a book of philosopher quotes, and a couple of note cards on different topics. That's all I had with me. Okay. And I used that for my 30 minutes. But in any event, long story short, I won the New York Long Island Regional, went to the state competition, and finished second in the state that year. And the guy that beat me was Joseph Cowley, who went on to be a professional actor. And he played the role of Joey in Saturday Night Fever. So I figured, okay, well, I was the only non-professional in the final round. But what that taught me was how to quickly organize your thinking, organize it well, spontaneously, and being able to make an effective presentation. So when I got to the point of what am I going to do with my life, I had this mission, and now I've believed I had this skill set to go in and argue and go in and convince. And I said, that's what I'm going to do. I'm going to use that as a trial lawyer to sort of meet what I felt my purpose in life was.
So how did you establish a trial practice? Did you have some early mentors? I mentioned earlier, you've been doing this now for over 40 years, and you had your own firm. You went to national firms. But most lawyers are good lawyers, but they don't know how to run anything. You have a unique set of skills. You're not only a great trial lawyer, but you actually ran a business, your own business. Talk about the journey there.
Oh, thank you. That really is an important point. Graduated law school, figured, I want to probably be a trial lawyer, clerked for Jack Day on the Court of Appeals. And I had 2 years of clerking for him to counsel with him to write appellate opinions on the cases he heard. But the real part of that job was at 5 o'clock, he would have me into his chambers and we would sit there for 2-3 hours talking. Sometimes we went to lunch, sometimes we went to dinner. In those 2 years of conversations, I learned, just like you talked about, all the things that he had done, all the tough cases he had tried, and what he thought about being a trial lawyer. And he was, all throughout my life, the most important mentor I had. And then there was David Sindel. It was the first law firm I went to right after I clerked, was a friend of Jack Day. He introduced me to David. And I told David, I said, I don't want to work for a salary. Just give me a percentage of what I win. And he didn't like that. He said, no, I had to take the salary.
Because he knew you were probably going to win some big verdicts. That's why.
But I did make that proposal. My wife didn't like that. So David did the same thing. He would take me to lunch. He would sit in his office for hours at a time telling me things, cases that he had and so forth. So between Jack Day and David Sindel, I wanted the life of a trial lawyer, and I figured I could do it. And that's when I sort of set out with that as my goal.
There's a stereotype that trial lawyers deal primarily in personal injury, but that's not really true. Trial lawyers deal with business litigation as well, and in fact, that's been really the focus of most of your time as a trial lawyer. So let's talk about how you developed this practice, starting with your own firm, Kaufman and Cumberland, all the way to retiring from Ulmer and Byrne.
That was a long journey, Lee.
Yes, I know. 42 years, I think, right?
42 years of building a law practice. Right at the time, I was planning to leave the Sindel firm and knew that I wanted to be on my own. My folks had taught me to have confidence in myself and that I could do anything I set out to do. I wanted to be independent. I didn't want to depend on anybody else. My dad had worked for a large company for his whole career, and I saw how that could beat you down, that you're always at somebody else's beck and whim and what they wanted you to do. So I wanted to be independent, but how was I going to do it? I read a book called How to Build a Law Practice in my last year at the Sindel firm, and it was written by Jay Foonberg, American Bar Association publication. And I joined the Cleveland Bar Association, and they had a solo practice committee. And David Burge on the east side of Cleveland had a solo patent practice. And I worked with Dave to figure out how solos could make it. And we ran a program for a year or two at the Cleveland Bar Association. So when I went through all that, read the book, did the program, thought about my parents' advice, I said, I could do this. It's going to be hard work, but I could do it. So you're right. I set out, I left the Sindel firm, had a solo practice for 3 years, and then I got to the Kaufman firm. And we built that.
That was like 1982?
1982. And it was just hard work. I'll do any case at that point. I took assignments from the juvenile court to try cases for mothers whose kids were being taken away from them and other types of issues before the juvenile court. I tried dozens of cases there and learned how to try a case quickly without any discovery. But it took time. And over time, I was able to build a very large book of business with big cases and large clients, or large disputes, I should say, because a lot of the clients were individuals who were on the bottom of a mountain trying to fight uphill with a bet the company type situation for them. So I was able, year by year, over time, to keep building on the successes of prior cases. And there was word of mouth, and clients would talk to other potential clients. And 42 years, that practice just kept building and getting wider and deeper as a result of success after success. Didn't believe in advertising, didn't believe in anything else. And I did a lot of community work, which got me out into the community, which I think was very helpful in having people know who I was. But building the law practice was really built case to case and success after success.
You're a good example of the fact that most people, when they think of advertising, they think of television ads or radio ads. But the best advertising is success. And you've proved that.
That's what I thought. And, I don't mean to suggest that I tried every case I had. You know when to try them and you know when to resolve them, because you see the risks for your client and you counsel them on it. So when I talk about success, I talk about either winning a dispute that's unsettleable or coming to a result that was really in the best interest of my client after a hard fight.
It's very hard to develop a practice, but it's even harder to develop a national practice. That's what you did, which is highly unusual. You went well beyond the bounds of Cleveland. Talk about that.
I didn't plan that. The way it worked is client after client would refer others, and pretty soon I was attracting New York work. I was attracting Chicago work because clients knew people there, and it became quickly apparent that I needed to be a member of the New York bar and I needed to be a member of the Illinois bar, which I did, and which got me local recognition in addition to bringing the skills in. But we opened, and this was Kaufman and Company in the later years, and I had done some of this at Thompson Hine, offices in Chicago, Washington, and New York, as well as Ohio. And it was just basically where the work was coming from. And as I began to develop clients and get results in New York and in Chicago, more work came in. one of the things that happened in my career is because of the nature of the matters I got. Many of them were public in nature. They were either public organizations or government agencies that had a public profile for the case. They were clients that had roles in foundations or trusts that had very high public profiles because of who they were. And these disputes get covered by the media. So a lot of my cases were covered in newspapers, TV, and radio, and people are learning about this lawsuit and this trial that's going on. That was a huge source of word of mouth and new work that came in as a result of those things. So it took time, but that was one of the aspects of taking on a tough case for a tough situation for an individual or an organization and fighting a case that had principles associated with it. That was the reason, I think, for the success.
Steve, I want to turn to stories. Let's talk about your first case. Cleveland Heights Municipal Court, Judge Sarah Hunter.
Yeah, I was at the Sindel firm. It was the very first trial I ever had. It was a jury trial in a criminal court. And I didn't know a darn thing about trying a case at that point. I'd never done it. So Dave Sindel and other partners at the firm really mentored me before that trial. And I went in with one other associate from the firm, Steve Wolkin, and we tried that case. And these two guys, one white person, one African-American person, both about 18, 19, were arrested and charged with all sorts of violations in Cleveland Heights, environmental statutes, trespassing, burning, and all that. There was a leaf fire in front of some house. And that's what it was. And they threw the book at these kids. It was a clear case of racial profiling, but these kids were caught in the vicinity, and that was their reason for the arrest. So we tried that case, subpoenaed the police chief, the fire chief, tied up the city government for 5 days, and it resulted in a hung jury. And the one thing I learned about jury selection, I allowed to stay on, and the other side didn't knock her off, the prosecutor, who was a roommate of a person who worked for the ACLU. And she ended up being the foreperson, and she got the defense. So that was my first success, and the only criminal case I ever tried, by the way. I just didn't want to do that anymore.
What's remarkable to me is that I don't think you ever second chaired a trial. You always were the lead counsel. Is that right?
Yeah, thank you. Yeah, that was the first case I had, and I never second chaired any trial.
That's highly unusual.
Yeah.
Yeah.
Yeah, it was trial by fire and taking on the responsibility early, and I had nobody to watch in the courtroom other than times that I would see videos. I was a member of the American Trial Lawyers Association early on, and I would rub elbows with some of these national legends and go to programs and heard them talk, and I kind of learned from them. Keep it simple, talk to the jury, talk to the judge. Just don't go in there and try to be a law professor.
What's the biggest case that you ever worked on that you won? If you had to just pick one, what's the one that stands out for whatever reason?
Well, I guess because of the stakes, representing the city of Cleveland. Cleveland owned the IX Center and 150 acres of land around it. Mm-hmm. And Brook Park, the city in which the land sits, and the neighboring city, under Mayor Tom Coyne, filed an eminent domain action to take the IX Center and all the land because they wanted to have an economic development program. And this is before the U.S. Supreme Court ruled that that was a proper purpose. At that time, it was uncertain. And that was the big case. And all the media, all the pundits were saying that based on the facts in that case, Cleveland was going to lose the case, that they were just going to lose the case, lose the land. And that land was critical to airport expansion that was anticipated in 25 years for a third one-way. As it turned out, it didn't happen. But we had a judge who didn't particularly like our side and liked Brook Park because he and the mayor of Brook Park were friendly, and made the mistake at a discovery hearing to which my side wasn't invited. It was a dispute between the IX Center that didn't want to produce its financial records and the city of Brook Park. And the judge made the comment during that conference that Cleveland was going to lose the case.
Wow.
And he had already kind of decided for his own reasons that Cleveland was going to lose. So I found out about that night. We ended up filing a motion before the Ohio Supreme Court to disqualify that judge, which we were successful on. He ultimately recused himself. We got a fair judge, I thought, tried the case for 5 weeks and won. And the Cleveland Plain Dealer called it a major victory for the region because the damages in that case to Cleveland would have been in excess of $4 billion if Brook Park had succeeded in taking the case. And we didn't think they had the wherewithal to pay it, but that would have been the damage to Cleveland based on the value of the airport.
Now, you had some other big business litigation cases. Talk about one or two of those.
I'm talking about the eminent domain cases first. If you
Eminent domain is perfect. Although explain eminent domain for those few people may not know what that is.
So eminent domain is where the government takes private property for a public purpose and they have to pay under the Constitution just compensation. These were the first federal jury trials I ever had. And back in the early 80s, I got the first referral, went to the law library and read 2 volumes of Nichols on eminent domain because I didn't know a darn thing other than the law school class. Went in, tried the first case, won the case, got a verdict in excess of our appraiser's opinion and just below the owner's opinion of value, which you can do in an eminent domain case. So I walked into Judge Thomas's room for the second case 2 weeks later for a related family member, and he said, "You're not going to do in my courtroom what you pulled down the hall with Judge Aldrich." And he prevented me from putting my expert on. I fought with the judge in sidebar for 2 hours. He eventually said, "You know what? I can't take this anymore. I'm going to call a courts expert." He called an architect who had restored the judge's home in Chagrin Falls, who he said would know and be competent to testify on the historic value of the property. And then my appraiser would talk about the premium that the market would get. Well, that guy comes out, tells the judge it's the most historically valuable home he'd ever seen in his life. The jury hears this. We got a verdict, again, in excess of our own appraiser. And I had 5 in a row like that in the federal court. And I settled every case with the government after that. And these were all Cuyahoga Valley National Recreation acquisitions by the federal government. And then I had the airport case, which I got as a result. So in terms of business cases, I had a very substantial case for Cleveland involving LTV Steel. And LTV was in bankruptcy court. Jones Day was representing them in the bankruptcy. These ovens were going to be shut down because the bankrupt estate couldn't afford to pay for these things anymore. And so they were about to shut them down on a Monday. Cleveland hires me on a Thursday. They discharged the firm that was handling the case, hired me. They had the right as a creditor because they were selling electricity to come in. I went in and got a TRO on a Friday to stop the shutting down of the ovens, and we went into federal court, different judge on Monday, and we argued the case to him. There were no depositions. I had no discovery. I put the CEO of LTV on and the CFO of LTV on. I had nothing but news articles. I did 25-minute cross-examinations and got yes answers to every question, that yes, the public would give this money. Yes, the public would likely give that money. And by the time I got done with those 2 witnesses, and by the way, the congressional delegation sitting in the front row, Stephanie Tubb-Jones, Dennis Kucinich, the judge called a break. He said, "I want to see everybody in the back." And 4 hours later, we had a settlement. They kept the ovens going for another 5 months. Cleveland was able to find, or they were able to find, a buyer for the assets, and those ovens didn't shut down and we didn't lose the jobs. I would consider that one of the biggest business cases I won in 4 days.
That's amazing. And it's amazing also that you knew nothing about eminent domain and soon became the eminent domain expert.
That was just the way life works. And the business case I'll talk about is the case that I had for the representative of the Hoover Foundation.
Ah, yes.
This was portrayed in the media, all the newspapers, because this was a battle among the members of the Hoover family. I represented the former chairman of the board, and on the other side were all the other Hoover's cousins that were on the board of the foundation. And what happened was that the foundation got dealt to an independent spinoff. My guy was kept out of the mix, had no participation in the sale of the company, no participation in forming a new foundation. He was on the outside. So we filed a lawsuit for breach of fiduciary duty. The attorney general came in, quickly sided with our side of the case, and we go to trial. And because that was unsettleable, and we had been told that we were going to be sued for fees, I was going to be the subject of a disciplinary action. This is all being said by the opposing lawyers, big law firm. 3 weeks before the trial, and I won't bore you with the detail, I got the hunch to subpoena some records from a third-party law firm because the defendants had produced not a single shred of paper showing this plan that they had to spin this foundation off for their own control. I subpoenaed this third party 3 weeks before trial. We got a treasure trove of documents that showed what the whole plan was. And these guys had never produced it. So, you wonder where the documents went. So in the middle of trial, we were able to have the tide turn. And when I announced that I was going to call the main defendant, who was unprepared for these documents, I saw no deposition, saw no sanctions, just said on a Friday afternoon, I'm going to depose this guy, take his testimony Monday morning. He showed up, the guy was hospitalized, and the judge told the other side, you better go out there and settle this case now. And as a result, we were able to save that foundation and curtailed the lifetime control that these guys were going to have. And my guy had a role in a reformulated foundation.
Steve, I want to turn now to a part of your career which is fascinating to me because you were fearless. You would come close to being held in contempt if you felt that you needed to argue until you won. And I know of at least a couple cases where that was an example. Can you talk about those stories?
Sure. And, I learned to be a professional, which I always was. I never crossed that line of not being professional, but I took zealous advocacy seriously. If I felt that I was going to lose a ruling that was going to really destroy my case if I'm in the middle of trial, I had to fight for that position if I felt I was right. And so this first situation that came up was in the early 80s. I was trying an eminent domain case again in federal court before Judge Dowd in Akron. And this was for the individual who had organized all the homeowners in Cuyahoga Valley to oppose the federal takings of property. So he was a target of the federal government. They had picked his property, which was a 1854 restored farmhouse at 150 acres with all sorts of other buildings on it, totally unique piece of property. And they were going to take that, and they said they're going to make it the park headquarters just to stick it in his face. So we couldn't resolve that case. And I sat with Judge Dowd before the trial started, and he said, look, the government is willing to pay your client some real money. Your guy is a very wealthy guy, which he was. Take the money. He says, you're before a jury in Akron. You're going to have a bunch of unemployed rubber workers on this jury. They're going to hate your client, and they're never going to award him any money. Take the offer. And I said, no, out of all due respect, we're getting underpaid and we're going to fight. He said, okay, take your chances, Steve, but you're going to lose and you're going to wish you had taken my advice. That's what he told me. So we tried the case, and I got to the most important part of the case was my expert, because we were going to show that this was so unique a piece of property that you could not use a standard method of appraisal. You could not find other sales of property that were comparable because this was so unique. You can't use a reconstruction cost approach because it would be not instructive of what the real value of this property was. You had to use a hybrid approach where you consider multiple factors and you come to a professional opinion by a registered MAI appraiser, which is the highest distinction an appraiser can get. So I get to that part of my case, and the judge said, I'm not permitting him to testify. He's not following a traditional method of appraisal, and I'm gonna prevent his testimony and move on with your case. So we had a United States Supreme Court precedent that said that a court has the discretion to use a hybrid approach where the property is so unique that using a traditional approach is unfair in a constitutional setting where you're talking about just compensation. So the judge ruled. I argued my argument again. He said, I'm denying it. Objection sustained. I argued again. I'm telling you, Kaufman, I've already been through this. I've told you why. No, the objection is sustained. I start arguing again. He says, you finish that argument, and I'm going to hold you in contempt of court. And I said, Your Honor, out of all due respect, I didn't continue the argument. I said, out of all due respect, I'm trying to help the court because I don't want to go to the Sixth Circuit and have to come back here and retry this whole case.
Because he would be reversed.
Because he would be reversed. When I said that, he turned as red as these chairs are. He said, I'm taking a break. He goes out. He comes back 30 minutes later. I think at this point he read the case.
Yes, right.
And he said, this is all against my better judgment, but I'm going to reverse my ruling, and I'm going to let you put that expert on. So we put the expert on, and we won a verdict far in excess of our appraiser, just below our owner's opinion of value. At the time, the paper said it was the largest jury verdict for a residential property in Ohio at that point. It never been received that high a verdict. The interesting thing in that case, besides the fact that the lawyer who was going to cross-examine that witness is now a sitting state court judge, I won't mention the name, but was brought into that case at the U.S. Attorney's Office for the express purpose of cross-examining our expert. And that cross-examination didn't work, and we had a jury of all women. I had found a way to strike all the men from that jury because I felt that the women could pay attention to the details in this home. There was French wallpaper, gold fittings, the most expensive finishes you could imagine, and I figured that these ladies would appreciate the value, and they did. So we got covered in the media for winning that case, and that taught me a lot of lessons, but I fought as hard as I could because if I didn't win that ruling, we were going to go down. We had no no way to win that case.
I love that story, and it's the perfect example of zealous, I would also add fearless, advocacy on behalf of a client, because you came right up to the edge of almost being held in contempt and then convinced the judge that he himself was wrong. That's pretty impressive. You had some other cases like that too. Wasn't there another case where you also pretty fearless?
Yeah, this one was in a different context. This was a case. I represented a national real estate developer against one of the largest tenants in malls in the country. And the tenant had brought a lawsuit against the developer, which basically challenged their lease practice all over the country for all tenants. And they said that they were being overcharged for insurance reimbursement and how the insurance reimbursements were calculated. And we were before a federal judge in Minnesota. Now, my opponent was one of the largest firms in Minneapolis. The judge was a very conservative judge who knew that law firm well. And the tenant was headquartered in Minneapolis. So we were in the other side's hometown.
So you're the out-of-towner that would put you at an immediate disadvantage.
Exactly. And they started this case just by making it a lease case, and then they added counts for punitive damages, attorney's fees, fraud, you name it, and the other side added these. So I was before a judge on the first major motion in the case. The other side argued and did a very good job in their argument, and now I'm up, and I'm in a deep hole. So I had done a lot of homework on this judge. He had handled the NFL Players League antitrust case. He was an expert on antitrust law, appointed by President Reagan, very conservative. And he was, probably in his late 60s at the time. So I start out, and I used something legal. And I don't know whether you did this in law school, but I did. I used to go home at lunch and just listen to Paul Harvey on the radio, which I thought he was a very conservative, but a great radio commentator. So I start out with the judge. I said, Your Honor, in law school, I would always listen to Paul Harvey. And I started to talk about Paul Harvey. He cuts me off in mid-sentence. He says, you know who Paul Harvey is? And I said, well, of course. And I told him a little bit about his radio show and what he did. The judge launches into a series of his own stories. We go back and forth, honest to God's truth, 25 minutes of repartee about Paul Harvey. I didn't even start my argument.
Did you know in advance that he knew about Paul Harvey? And
I had a hunch that from his era and his politics, he would follow this guy. Just like people watch Fox News. Yeah. Anybody who was into that sort of viewpoint would listen to this radio show. Yeah. So it goes on for 25 minutes. The other side is like falling under the table. Because I'm established, all of a sudden I established this rapport with the judge. And I said, Your Honor, let me, time is important here. Let me go back. I said, now I'm going to go to the rest of the story, page 2. Here's what they didn't tell you. And it launched me right into my argument.
Wasn't that his famous line, the rest of the story?
The rest of the story, page 2.
Yes, okay.
That was what he did. So I did that to start my argument. And we won every claim. He threw out punitive damages. He threw out attorney's fees. He threw out fraud. We got everything out, and the case is back to its basics. The judge found for them on the meaning of the contract, but I had my defenses that he said, well, there are no defenses really that you could litigate. I took him to the Circuit Court of Appeals. We turned the case around and sent it back to him, and it said, basically, you have jury trial on these defenses. And I had some incredible evidence. We had sanctioned this firm for discovery misconduct, for hiding the evidence that we had for our defense, that they had for our defense, didn't produce it. They got sanctioned, and the judge just told the other side, you better settle this case.
Wow.
And we got a result that was better, frankly, than it probably would have worked out if they had recalculated everything. It was a great win. It
sounds like the end of every story is the judge saying to the other side, you better settle this case because Steve Hoffman's going to win this case.
Well, that's the way this case went. Yeah. And it was an incredible experience. But, you learn who your audience is and figure out a way to even the playing field and have a dialogue.
Now I want to turn to my favorite stories. You represented 3 politicians, Senator John Glenn, Senator and First Lady Hillary Clinton, and me. Let's go first to John Glenn, then to Hillary Clinton, and then talk about how you helped me in my career.
I'd be happy to. I was hired to represent John Glenn. A firm had a conflict of interest. He was running for Senate, and it was a close race, running for re-election to the Senate. And it was a close race. He had a failed presidential campaign. He ran up a substantial debt that it took years for him to pay off, and it still at this point wasn't paid off. And a case was filed for political reasons. by a bus company that was still owed money from the presidential campaign. And this was filed and would have been litigated and been in the public eye for the period of weeks before the election. It was really bad politically. So I was asked to go in and somehow or other get this case out of the public eye. So there wasn't much of a defense because the services were rendered and the money wasn't there at that point to pay for it, maybe a partial payment. But I was able to go into the common pleas court, found a judge who would listen. And I explained, look, you don't want to be used as a political tool. I don't want to be used. We don't want the public being used as a political tool. Let's let this dispute get handled after the election. And the judge agreed after vehement opposition. And he rescheduled the trial for after the election, and that case was completely off the map. John Glenn became a client for life after that. I did all sorts of stuff with them, other matters that he needed help on. I was on a committee he appointed to vet federal judge appointments in the Northern District, and got to sit with the family when he went back into the space in his 80s. 70s actually, and got to watch him do that. So
I remember that.
That was a great experience. Yes. But your situation, I was working for your campaign to have you get elected Ohio Attorney General. You were running against Paul Pfeiffer. You ran a great campaign. On election night, you were winning by, in excess of, 1,300 votes, as I recall. It was a razor-thin margin, but you were winning. There had to be an automatic recount. The official count had to be certified. We went through all of that for a period of weeks. But you were facing an election contest that would be filed by your opponent. So he files it, and you engaged 3 law firms to represent you. We had two law firms. We had the Porter Wright firm and former Judge Richard Marcus and Kate O'Malley, who since became a federal judge, and then the Kaufman and Cumberland firm and myself. And so we collaborated on this case. The first thing that we did before the election contest was filed, when I was representing you, figuring what moves should we make to position you in an election contest as favorably as we could position you if you were going to be winning by a small number of votes. So this was the first year that there was a lot of issues about provisional ballots, about people changing their address close to the election, about mistakes on ballots and how you deal with those, and believe it or not, hanging chads.
Long before Bush, Gore,
long before
Trump, Clinton, all that. That's right. We were the pioneers. That's right.
But these were issues in your case. Why? Because it was so close. Mm-hmm. And all of a sudden, those procedures were going to get scrutinized.
Closest election in Ohio state history, even to this day.
It was and is. Exactly. So you are in history forever.
Yeah, that's not exactly how I want to be in history, but I'm in history. That's
but
right.
You won.
Yeah.
So what we did is we filed... and this was sort of, if you play hockey, and I played a little intramural hockey, you do a head fake. You go one way when you really want the other side to figure you're going to go the other. And we filed injunction actions in almost all the Ohio counties to prevent the boards of election from mixing all the different types of ballots together after they counted them, which would have put into one big pot all these different types of ballots. Why? Because if they do that, there's no way you could unscramble that egg later and figure out which ballots were which, and whether or not they should count or not count. So it was very difficult once you put them in a pool. But Ohio law said you have to put them in a pool. You take all identification off of those ballots once you do that. So we started winning these TRO motions, and we had a couple of dozen granted, and the other campaign didn't like that. Now, why did we do that? Because in an election contest, the loser has the burden of proving not only that a mistake was made, but that it changed the outcome of the election. And they would have had a burden of showing how many of those ballots either should have been counted that weren't or shouldn't have been counted that were, and that made a difference in the result. So long story short, they go into the Ohio Supreme Court with an original action to order that those ballots get mixed, and the court agreed. So now all the ballots are mixed, and they've just made it a heck of a lot tougher for themselves to win an election.
Ironically, it's exactly what you wanted, but they didn't know that.
Exactly what we wanted, and they just did the opposite, figuring, well, if they want it, then we don't want it.
Yeah.
And they must have had other reasons, but that's what happened. So we litigate the election contest. You were sworn in March.
No, I was actually sworn in
February?
January.
In January, okay.
In January. January 1991, I was sworn in.
That's right.
That's right.
You reminded me.
Yeah.
Because I was running around taking depositions.
You missed my inauguration because you were taking a deposition in the case for helping me. That's
exactly.
Right. Uh-huh.
And so we took depositions all over the state and argued to the Supreme Court, and you won a unanimous decision.
March 11th, 1991.
1,234 votes.
1, 2, 3, 4.
As easy as 1, 2, 3, 4.
Right.
And the court said, look, there were some mistakes that were made, but there was no clear and convincing evidence that they made a difference in this election. And so we won the argument we knew we had to win. And you were now officially the Ohio Attorney General, even though you've been serving for several months. And that was a huge win.
Right.
And then...
Well, I'm just going to say we won the recount. I get inaugurated, but if it hadn't been for you and Judge Marcus and Kate O'Malley, I wouldn't have been able to unpack my boxes because even though I was Attorney General, I knew I had this lawsuit hanging over me. So thank you again for allowing me to serve as Attorney General of Ohio.
It was my pleasure. And I do remember visiting your office, and I remember you had your feet up on your desk. I said, this is great. Lee's arrived.
Now let's talk about Hillary Clinton.
So Hillary, we got hired by the presidential campaign. It's on the eve of the election. Roger Stone and the Trump campaign were spinning all sorts of threats of violence at minority polling places, that people were going to be challenged for identification, really stirring up a lot of fears by people that wanted to come out and vote in minority areas in Ohio. So we went in and we got an injunction from Judge Gwynne to prevent all these practices. And we got an injunction, the only one that was received in that election in the country against Roger Stone and Donald Trump's campaign. And although that was overturned later on some technical grounds, all the media said, you know, the polling places are going to be safe, you're going to be protected, and that's what we needed to have the election done in a fair way.
You know, it's amazing. We could go for hours on all these stories, but I want to wind up the interview and talk about two areas, and that is your community service and your professional service. I know that one of the most important things you've ever done in your life was to serve as president of the Shaker Heights School Board. Talk about that.
Sure. My kids went to the Shaker schools. We lived in Shaker for most of our adult lives here and had the privilege of getting elected twice to the board. And that 8 years of service ending with 2 years as president was the most personally significant public service I ever put in. We had a very difficult situation with achievement gaps between, white students that had an advantage with their households and minority students that didn't, single parents, not able to spend time with the kids doing homework. And we fought the achievement gap. We did a lot of innovative things during my years, and we were very successful, and it was a labor of love. And I remember the last year I was president was the 50th anniversary of Brown versus Board of Education. And that was probably the best speech I've ever given, and talked to the folks about each individual, and I took a line from City Slickers, the beauty and uniqueness of each individual, and how each child that was graduating was that unique person, and they all now were going to get an equal shot at the world as a result of the Brown case.
That's great.
And it was just a great moment for me. But that was great service. And then, of course, the Cleveland Bar Association.
You were president of the Cleveland Metropolitan Bar Association, fondly known as the CMBA, from 2003 to 2004, and you were a very consequential president. Talk about that.
Well, thank you. I decided to bite off a lot that made a difference. So there were two big things I did. One was diversity, and I pulled together the managing partners of the 15 largest law firms in Cleveland, and we created a managing partner forum. And in that forum, I wanted them to find common ground on how they could all support minority clerkships every year, regardless of the year, without telling the student that they were part of some different program. We wanted everybody to understand that they were a clerk for a big law firm and have that chance, because if they don't have those chances, they never, as a group, get the opportunities that the more advantaged law students did. So we were able to find common ground, put that program in place, and it was hugely meaningful. And the second was I decided that I felt county government needed to be studied. We had a 3-commissioner system that was neither legislative nor administrative or executive. It was just one body that did everything. And there were no checks and balances. And we did a study, and you were a very significant part of that study, Lee, as you may remember, part of that committee that led that. And we did a study. We made recommendations on county government reform, held forums at the City Club all throughout the year on different aspects of that. And we issued our report at the end of my bar president year. Several years later, when there was a county corruption scandal, I worked with 3 other people, Mayor Rawson of Shaker Heights, Mayor Zanotti of his city, I can't remember. Parma Heights, and Bruce Akers from Pepper Pike, who, is a real guru on this kind of stuff. And the four of us, in our names, circulated petitions to get county government reform and the vision that we had at the Bar Association on the ballot. We raised the money. It won by 69% of the vote. And as a result, what started here in the Cleveland Bar and with other organizations earlier ended up with a significant change, for the benefit of the county.
That's very consequential.
It was a big deal.
Now, here's my final question of this interview. I'm going to ask a lot of the law students at our law school at Cleveland State University to listen to this podcast. So I want you to send a message to these law students. In a sense, here's the question. If you could write a letter to yourself when you were watching Man of La Mancha with Harris Wofford, and little did you know at some time you'd be going to law school and a lawyer, what do you wish you had known that day when you were watching Man of La Mancha that you know today in the form of advice to law students in Cleveland at Cleveland State and Case Western about how they should pursue their career?
What a great question. There are two things that came to mind as you ended that question. And I'm gonna sort of focus on what I did because I did trial lawyer and litigation, so it works if I use that as the lens. Mm-hmm. If you want to be a trial lawyer and litigator in the law, you have to get through incredible pressures, incredible hurdles, lots of opposition, lots of challenges. And there are two things you have to have. One, you have to have an overriding purpose and mission in your career. And two, you have to have the passion and the work ethic. You have to have a passion for this. And if you have the passion, and if you are willing to roll up your sleeves and work really hard for an objective that you've got, those are the things that you need. And I didn't appreciate that at the beginning. I learned that I needed to have this with me at all times to get through the challenges of the work that I did. Sticking with it, not being discouraged. Keep fighting. Keep moving your legs if you're a running back in football. Just keep going. And you can be successful. But you've got to have that. And, I would suggest students have to take a hard look at do you have those passions and do you have those objectives other than making money and having a title? Those don't last very long. You have to have that passion. I know you've got it because you've done it for your whole career. And those are the people that can be successful. Nobody quite told me that. I was an 18-year-old or a 22-year-old out of law school, and all I knew was this is what I want to do. I didn't know that I would have to have those things to get me through it.
Steve, I can't wait to read your book because even though we talked about a lot of stories, there are even more in that book. I'd like to suggest a title, even though you probably already have one, and that is Fighting the Unbeatable Foe and Winning. Because that's what exactly you've done throughout your whole career.
Thank you, Lee. And thank you so much for your time today and for the good graces of the Cleveland Metropolitan Bar for doing programs like this. I appreciate it.
Thank you for listening to the Bar Stories of Steve Kaufman.
Thanks, Lee.